Burns has been servicing client needs for 35 years. John Quincy Adams said it best: whoever tells the best story wins. So, here's our story.
Welcome everyone to the Genova Burns podcast series. I'm Tom Bergeron of binge.com. I'm with Matthew Baker, the partner at Genova Burns in the complex litigation department. And boy, do we have a story to tell you today. Everybody has heard about NIL, name, image, and likeness, and how it's taking over college sports for good, for bad, and for ugly. We're going to get into all of that. Matt, let's start, first of all, impact. NIL comes out. Everyone immediately thinks, okay, we can pay the players. This is going to totally disrupt the college football landscape. Teams will be up that were down. Teams that were down will be up. But yet here we are halfway through the season, and it's the same old teams that are still battling for the playoff. Give me your assessment about the overall impact of NIL on college football.
Thanks, Tom. That's a very good question. I think the best way to answer it is to say that the impact of NIL extends far beyond what we actually see on the field or on the pitch or on the diamond or on the court. That said, I think it's relatively straightforward to say that if you were a powerhouse program before NIL was allowed, that meant that you had a wide array of boosters and donors who were willing to support the program financially. Then you're probably still a powerhouse program now, and NIL has really given those boosters and donors a more direct way of supporting the program because they can support athletes in a very direct manner. That said, it has given some programs an opportunity to kind of reset and to reach out to their donors and boosters and their fans in general and say, look, if you financially support this program, then we can put a product on the court or on the field, on the diamond, that you will really be proud of, and that can really be competitive in our league. So I think it's really been kind of a mixed bag. It certainly has not been a panacea to address anti-competitiveness, but it's been good for some and not that great for others.
We think about the schools, we think about the conferences, we think about the big money, but we don't think about the players. For those of you who don't know, Matt was a Division I football player, pre-NIL, right? I want to take you back to that locker room. As you think about when you were playing, do you think, A, you should have been compensated differently, and B, if you were and you had a locker room where different guys were getting different amounts of monies, like you have in the pros, would that have impacted the experience? Talk about how NIL hits the players.
Sure. So when I played, and I played in the Ivy League where no one got any scholarship money, no one got any monetary compensation, certainly not as players are getting today. I don't think that the ability to receive compensation would have necessarily changed our outlook that much. It certainly would have been nice to have some more spending money while we were in college, to go out and get some pizza or
now you're sounding like every college student that's ever lived, which is okay.
Exactly. But as far as the concerns about camaraderie and things like that, and I remember that when people were debating whether or not college students should be able to monetize their NIL, college athletes should be able to monetize their NIL, that was one of the concerns. People said, what's it going to be like when you're in the locker room and the guy in the locker next to you is making twice as much money as you are, and those sorts of things. But, when you're actually in a locker room, you recognize that, look, star players kind of get star treatment no matter what. The star quarterback gets to talk at the post-game press conference. You might get invited to a golf outing. You might get other sorts of benefits. Obviously, there were caps on those types of benefits and other limitations and rules that applied to us when I played from 2002 to 2006 that are not necessarily in place now. But look, when it comes down to it, if someone's producing on the field or on the court, then you're not going to begrudge the fact that they might get some level of additional treatment, beyond what you might be getting. And if you're the star player, if you're the star point guard or the star quarterback or the star softball pitcher, then I think it makes sense for you to say, well, I see all of the merchandise that fans are wearing in the stands. I was the person who helped score those touchdowns or score those runs or score those goals in a soccer game or something like that. Why can't I get compensated in part because of the the positive monetary influence that I'm helping cause. So I don't think it has really changed too much about the actual player experience.
So I'm going to bring in, we are on the Genova Burns podcast, so we're going to do some legal issues here. So I'm going to test my lawyer here. Are you surprised as an attorney? Do you think we're going to get to a situation where all of these players are going to have legitimate contracts that have been vetted by people? Because right now it's a wild west on who's getting what. Can you see that scenario coming where you're literally not just signing a letter of intent, you're signing your work contract, which gets to our other lawsuit about whether they're employees or not? Do you see that part coming up?
Sure. So I think, the current state of affairs is, most players can sign an agreement for their contract, and then once they come on campus, they are eligible to sign an NIL deal with their school if their school has opted into the house settlement. They're also eligible to sign NIL deals with other third parties, outside third parties. Now, they have to submit those third-party deals to a newly created entity called the College Sports Commission through a portal called NIL Go. And there have been some initial hiccups with the administration of that system. But that's the current kind of state of things, generally speaking. And not all athletes get NIL deals with their school. Schools have had to basically kind of triage. They've had to kind of say, all right, we're going to devote X amount of NIL funding within that $20.5 million cap that the House settlement requires, or that the House settlement allows. We're going to devote some of that money to athletes from this sport. We're going to devote a smaller portion to athletes from this sport, and maybe this sport we're just going to keep on scholarship basis. So that's the kind of overall state of things. I do think at some point there may come a time when the administration of NIL payments by colleges with their own athletes, combined with difficulties trying to get a handle on the administration of third-party NIL deals, some of which are not necessarily being reported, and some of those deals, are for services that the athlete is supposed to provide that maybe the NCAA or the CSC doesn't necessarily think are worth that much. There are going to be fights about that. But I do think that at some point, people who make the decisions with regard to the NCAA and Division I might think to themselves, it would just be easier if we could just sign athletes to a contract. And that way, both parties are clear about what the expectations are. One of the issues that I've seen pop up is commentators kind of decrying the fact that an athlete can sign with a school and get NIL money from that school, and then in the off season they can transfer to school number 2, and they sign, get a scholarship and get NIL money from that school, and then in the off season they transfer to school number 3. I saw a proposal the other day where someone suggested that athletes have to choose between either taking NIL money from school or the ability to transfer. But once they take NIL money, they shouldn't be able to transfer. Setting aside the kind of legal aspects of that, which I think might be, it would be difficult for the NCAA to impose a rule like that without potentially running afoul of the antitrust laws. I think, one of the issues with a proposal like that is you've got coaches who can basically do the same thing. If a coach does well in one place, there's nothing preventing him from resigning from that job and taking a better job the next year. And if he does well there, there's nothing preventing that coach from doing the same thing at a third school. I think at some point, both sides, both the players and the administrators, might look around and say it would just be easier if we could sign a player to a contract. That way, that contract could be maybe a 2-year contract or a 3-year contract. Everybody could be clear about what the expectations are as far as the player's commitment to the program. Everybody could be clear about what the expectations are as far as the program's commitment to the player, both financially and in other ways. That I think might be a cleaner way to go about this.
For those of you scoring at home, I just want to clarify something. When we talk about the House settlement, has nothing to do with the House of Representatives, a common misconception. The gentleman named House, whose lawsuit ended with, you said $20.5 million that schools can choose to divvy out among their players. And that leads to the next part of conversation here. We've talked about football. We can assume how it goes to basketball, but NIL can have a great impact on the non-revenue sports or the Olympic sports. And I think a great example of that was last year. The Texas Tech softball team decided that they wanted to compete for a national championship. They went out and signed the best college pitcher there was. They signed a half a dozen other women, and sure enough, there they were in the College World Series. Talk about how NIL, any school could take a gymnastics team or a tennis team or a soccer team or a softball team, and through a little bit of funding, become the king of the hill and probably do it a lot faster than, say, you'd be able to do in basketball or football.
Sure. So, and this is one of the ways in which NIL can serve as somewhat of a great equalizer among schools. If a school wants to be competitive in a particular sport, and maybe there isn't a wide array of other competitors in that sport, then that school can devote resources to, like you just said, recruiting and signing some of the best players that they can. One of the ways in which I think the House settlement, which, as you mentioned, was a settlement of a class action litigation, and through that settlement, a revenue sharing program was implemented whereby schools that opted into the settlement could share with their own athletes as much as $20.5 million of the school's money this year, and that amount will increase incrementally in the coming years. But one of the ways in which the House settlement, I thought, disadvantaged certain schools was that this $20.5 million cap applies equally to schools that want to be as broadly competitive as they can in a number of sports. Take a school like, I don't know, just Stanford, for an example, which is known for having lots of sports, for offering lots of varsity sports, and for trying to be competitive in almost all of them. They have the same amount of money that they have to divvy up as another school that, let's say, is only focused on football and basketball and maybe a couple of other sports. There are rules with regard to the number of sports that you have to offer in order to maintain your status in Division I. And so there's not a chance that there's some school that only offers 4 sports that's just going to flood the market with NIL offers for stars in those sports. But take a school like Texas Tech, like you mentioned. They were able to recruit and sign using NIL funds some very good softball players. I think one of the questions that I've had when I saw that story was, I wonder if this is going to take away from their efforts to be competitive in other areas, right? And maybe not football, maybe not men's basketball. Those are kind of spotlight sports that generate revenue for other sports. But maybe women's soccer, maybe volleyball, maybe men's soccer, maybe other types of sports that don't get the spotlight. NIL funds that might go to some of those athletes might not find their way there ultimately. But I do think it gives colleges at least an opportunity to kind of say where they want to be competitive, and if they want to devote all of those funds or most of those funds to football and basketball, the revenue sports. There may be concerns with regard to Title IX, right, which is the law that requires generally equal treatment of men's and women's athletes. But separate and apart from that, that may be sacrificing other sports, Olympic sports, non-revenue sports, that might not turn out to be in that school's long-term best interest.
It's funny, if 20 years ago we'd been talking about conference realignment, 40 years ago we've been talking about this thing called Title IX, which fairly says that the same resources need to be developed to men and women's sports. I think that this could be, you tell me, the next legal avenue of NIL is how it impacts Title IX. Who's getting more money? Is that fair? Are sports being, if not cut, severely neglected, which is a Title IX violation? How does that play out moving forward, making sure you have equality with the genders when you certainly don't have equality in in NIL? it seems like this is a lawsuit waiting to happen.
So that's a very apt way to put it.
I'm just trying to get to business. That's all I'm trying to do here.
Sure. So during the House litigation, one of the kind of recurring themes, especially of the members who were in the plaintiff's class of athletes, so ex-athletes and current college athletes, who objected to the settlement. One of the most common objections was, we think that this either does or will violate Title IX. And specifically because many of the schools that were going to opt into the House settlement signaled early on that they intended to take that $20.5 million pot and send most of that to football and men's basketball players. And there's a real question as to whether or not that violates Title IX. There are arguments on both sides. I think the potential objectors, the potential plaintiffs in any Title IX lawsuit would say, look, this is the school giving benefits disproportionately to male athletes and not to female athletes. That's a clear violation, period, full stop. I think the schools and the NCAA would likely say these were not the types of benefits that Title IX was meant to ensure equal distribution of. These are NIL contracts between schools and athletes, and because of that, they are in effect kind of market-based, individualized transactions, and these aren't the types of broad-based benefits like scholarships or like facilities that Title IX was really meant to cover. Okay. And there's actually one more aspect of this Title IX issue that I think is interesting and that I'm not sure is on everybody's radar, but there's at least one pending lawsuit that argues, in part, that not just payments from the schools are subject to Title IX, but that when the school cooperates and coordinates with its NIL collective, right? NIL collectives, which are groups of boosters or donors, usually wealthy alumni, that have gotten together and attempted to kind of funnel NIL money to the particular athletes at a certain school. When a school coordinates with its collective, and the collective pays NIL funds to certain athletes, signs certain athletes to NIL deals, those payments as well might be subject to Title IX because, in effect, it is the school acting through the collective. That's an interesting issue because, at least an interesting issue to me, because the big question now in big-time college sports is, how do schools get money to their athletes over the $20.5 million cap? And one of the ways that schools are starting to do that is by contracting with apparel companies or media rights companies to provide services to the school, but as part of those companies' payments, the schools are asking, can you set aside a couple $1 million for NIL efforts for our athletes? So really what you have is the school entering into an agreement with a third party that, as part of that agreement, the third party setting aside certain payments for certain athletes. If those payments, I could see someone making the argument that if those payments go primarily to football and men's basketball players, then that is also a violation of Title IX. No one has necessarily, no judge has decided that issue yet. I think that issue is pending in one case. I'm not sure if there are any others that are pending, but I would expect that any Title IX lawsuit against a kind of big-time school that's opted into the House settlement would probably include allegations regarding payments by a collective or payments by another third party that the school contracts with that also might be in violation of Title IX.
There you have it. NIL, competition on the field, competition for athletes, competition in the courtroom. It's all coming. He's Matt. I'm Tom. Thanks for joining us.